Welcome to the next edition of War Story Wednesdays. Today we're going to talk about that sweet young couple who buys their first house. They are just excited as can be. They've saved up, they've scrimped, they've searched and searched and searched to find just the right place. And they finally find one. You know, the real estate agent takes them through and shows them the house and gives them the disclosure packages, and part of that is a natural hazard disclosure statement. And it's just got a bunch of stuff, whether it's in an earthquake zone or a military ordnance zone or an airport zone, or there's even one part that says, be careful of golf balls if you're near a golf course. Of course, part of it is also talking about flood zones, and the agent discloses that the property's in a flood zone because, well, it is. The agent doesn't say anything more about those disclosures. Well, it turns out that the property is in a flood zone, and what that means is that if any part of the property is damaged or is destroyed, that the sweet young couple cannot repair or rebuild it. So basically what they just bought was a house the way it is with never the ability to fix it. Wow, that's not what they bargained for. So they sued the real estate broker for non-disclosure. They said that the house was a non-conforming use inside this floodplain. And the Court of Appeals struggled with that because, you know, you want to protect the sweet young couple buying their first house, or anybody buying a house for that matter. But the question came down to what was the legal duty of the real estate broker with respect to the extent of the disclosure that's made. The real estate broker disclosed that the property was in a flood zone, but didn't disclose what that meant. Was mere disclosure of the existence of the zoning enough? And the Court of Appeal here said yes. The legal ramifications of being in a flood zone was something outside of the scope of the disclosure requirement of the real estate agent in this case. And so the sweet young couple got their house that they couldn't rebuild or repair. And the real estate broker had no liability. Was it the right decision? You know, there are cases that say that the real estate broker has an obligation to make sure that the client understands the material facts related to a property. And there are cases that say that the broker doesn't have any obligation to disclose the legal ramifications of such a fact. I don't know if I would agree with the Court of Appeal on this one. Take your chances. The better course of valor, in my opinion, is to make sure that your client understands what you are disclosing to them, especially if you're the buyer's representative, because the fiduciary duties there are much broader than merely a visual inspection like those for a listing agent. Be careful.